best podcast, the Heidelcast.
It's a Heidel minicast. And now, Scott Clark.
So if a Christian were to sue a government agency, how would he go about it?
If the Heidelcast helps you, won't you help us keep it going? Please make the coffer clink by clicking on the PayPal link or by sending a check to Heidelberg Reformation Association, 1637 East Valley Parkway, number 391, Escondido, California, 92027.
Have I mentioned that we are on YouTube? I think I have, but we are. Presently, what we're doing on YouTube is uploading a lot of the older episodes, particularly the series. And then when that's done, we will be uploading the most current episodes. So if you are a YouTube podcast consumer, ordinarily, you could find us there. You can also get the Heidel app. It's free. It works. It's beautiful, according to the users, and we think that you'll like it. How do lawsuits work? This is part 10, and the last part of our series on POPLL: prayer, organizing, persuasion, legislating, and litigating. This is an alternative to Christian nationalism and theonomy and Christian reconstructionism and theocracy and Christendom. So, how do lawsuits work? Well, first of all, let me say I'm not a lawyer, and I am not practicing law on the Heidel blog or in this podcast. I'm just doing civics. That's all I'm doing here. So what follows should not be construed as legal advice, but broadly, there are two kinds of court cases, civil and criminal. Criminal cases are tried by state prosecutors, usually on the basis of evidence gathered by law enforcement agencies. A civil case may be pursued by any aggrieved party and is not dependent on the state for prosecution. Before an individual or an organization may litigate against, for example, a government agency, there are some conditions that have to be met. One, is there a case? And two, does the plaintiff have standing? Those are the two big things. There are probably other things, but those are two of the bigger ones. The first test is whether there is a case. One or an organization may not like an action taken by an agency of the government, but what matters is whether the agency has the legal authority to take such an action. A diligent layman might be able to determine whether the law authorizes an agency to do something. And of course, as I'm talking to you, we're having a national discussion about what the executive may or may not do legally. But it's probably wisest to consult a friendly lawyer. As much as we Americans like to make fun of lawyers, they do have their uses, and this is one of them. Good lawyers know the law, and they study the law in their areas of specialization. Just as there are medical specialists, so too there are legal specialists. Your neighbor who practices contract law probably doesn't keep up with the details of the law that affects your proposed case against, for example, an agency of the government. She might be able, however, to refer you to someone who is able to help you. Your local bar association also has a referral page, and there are also legal organizations, both religious and secular, who specialize in litigation to protect, for example, civil liberties. Beware. Not every organization that advertises itself as a civil liberties organization really is such, or not every civil liberties organization, so-called, will sympathize with your case, but you may be able to find a lawyer willing to advise you. Some of them even work pro bono, that is, for the public good, and because they are funded by generous donors. In some cases, you may have to raise funds, or in some cases, the lawyer might take the case on contingency, that is, he or she is paid out of an award granted to the plaintiff by the court. Second, a plaintiff, that's the side with the complaint, must have standing. Your lawyer must be able to demonstrate to the court that you have a right to bring the case. Simply because you don't like what an agency has done, or because an agency maybe has even acted illegally, doesn't necessarily create standing. Ordinarily, a plaintiff must be able to show that their interests are directly involved. Again, a lawyer can tell you whether he or she thinks you have standing. For example, if you have children in a school district that's pursuing a policy or a practice that is illegal or that puts children at undue risk, You might have standing in that case. You might have standing if a legislative body passes an unconstitutional law. Civil rights organizations regularly file lawsuits against cities, counties, and states that enact laws that contradict the Constitution of the United States. For example, should Congress enact a law forbidding Americans to criticize members of Congress, presumably every American would have prima facie grounds for contesting that law in federal court. Now, litigation is hard. It is expensive. It is slow and frustrating. So let us imagine that your organization has a case, standing, and funds, and thus begins to file suit against some agency. There is research to be done. What are the relevant legal precedents in this field? That is, what, if anything, have other courts said about this question? Where is the appropriate court to file suit? These and many other questions have to be answered. If a court determines that there is a case and that the plaintiff has standing, the judge will ask for briefs from the lawyers on the history of the matter, that is, who did what to whom, and what are the legal precedents. There is discovery, hearings, postponements, and more hearings. When the case finally goes to trial, it may take one day or it may take a week. After that, there's more waiting for the court to make a decision and to issue a ruling. However the court rules, one side or the other is likely to appeal, and then the case turns to procedure. Not the substance, but procedure. Did everyone follow the rules in the first trial? Altogether, depending on how the case proceeds, how long the funds hold out, and the willingness of the parties to continue, it might take, now not always, but it might take years for a case to get to court and then to be resolved. There's no guarantee in this world that a righteous case will prevail. This is why a good lawyer will give you honest advice from the beginning. There are good cases that, for a variety of reasons, are unlikely to succeed. Sometimes the court simply says, for example, in the case of the Supreme Court of the United States, it may just say, we don't think this issue is ripe. It's not ready to be decided. We're not ready to decide it. We want to see more litigation. We don't want to upset things. They can do what they want. So, depending on the relevant courts, a righteous case may not be able to find a sympathetic court or jury. The composition of courts varies. For example, in recent years, a 3-judge panel in the Ninth Circuit has voted one way on some civil rights cases, only to be overturned by the whole circuit sitting, as they say, en banc. The United States Supreme Court receives many requests to hear cases on appeal, but the Supreme Court can only hear a relatively few cases in any term. The court regularly votes not to hear cases, as I say, because they're not ripe. That is, the case, in their view, is not ready for consideration, or perhaps the court just doesn't want to tackle that issue. It took 50 years for the Supreme Court to overturn its own rulings in Roe v. Wade and Doe v. Bolton, even though it was pretty clear that Doe and Roe were badly decided. The same's likely to happen with Obergefell v. Hodges regarding same-sex marriage, which was equally badly decided, and I think eventually the court will see that. Further, it's difficult to sue an agency of the government which, reasonably, has broad immunity from litigation, and it has more money to defend itself than your organization has to litigate. The state has a whole army of lawyers to defend its decisions. The federal government has a phalanx of lawyers to defend whatever it does. Further, an agency must have a certain protection from constantly defending itself in court. Imagine if a police officer was subject to being sued every time he wrote a speeding ticket. He would never write any speeding tickets and life would devolve into chaos. So, any suit against an agency must overcome the general presumption of immunity. It can be done, but it's difficult and it requires patience.
The Heidelcast.
This is Heidelcast News. After years of planning and months of programming, it's here. The Heidel Shop. You've told people about the Heidelcast and Heidelblog. You've even shared posts and podcasts. Now you can show them. That's right. Hats, t-shirts, hoodies, coffee mugs, stickers, shopping bags, and even onesies. If you're into that sort of thing. It's all right here at heidelblog.net/shop. heidelblog.net/SHOP. It's the Heidel Shop. It's here, and you know you want to see it. You can't help it, can you? It's almost a compulsion. It's okay. we won't stop you. Call or text now, 760-618-1563.
So here's some final thoughts for the whole series. So I've presented this series for two reasons. First, to demonstrate that nothing about distinguishing between the two spheres of Christ's sovereign administration of all things requires what the theocons, the theocrats, the theonomists, the reconstructionists, and the Christian nationalists mock as quietism or pietism. Perhaps they've forgotten the words of the Apostle Paul. We are to pray for all people, for kings and all who are in high positions. That's Scripture. In order that, again, Scripture says, we may lead a peaceful and quiet life, godly and dignified in every way, close quote. That's 1 Timothy 2, 1 and 2 from the ESV. Second, these 5 points, POPPLL, provide an alternative way of thinking about our place in a post-Christian culture. The Theo Recon program of pamphlets, posts, and podcasts may be exciting, but it's really nothing more than posturing and, as I've said, cosplay, that is, dressing up. So let me illustrate. The other day, somewhere on social media, I watched two men run an obstacle course. One of them was a United States Marine. The other was an impressively muscled bodybuilder. And I thought the weightlifter, the bodybuilder, would have no trouble with the course. The whistle blew and the men began. The Marine, despite being smaller than the weightlifter, completed the course swiftly and efficiently. He had functional strength. He had experience and skill, the virtue of which we've discussed in this series. And he was strong where he had to be to get the job done. The weightlifter finished the course, but only slowly and awkwardly. The Marine was ready for combat. This is the difference between setting fires in November and actual constructive engagement with other citizens to improve the life of the community. 4 of the 5 points may not be your calling, as I've been saying, but one of them certainly is. You must pray for those whose calling it is to serve as God's ministers of temporal justice. Serving as a minister of secular justice is a good and important calling. It's a hard calling and frequently thankless. Few Americans have ever read a law, let alone drafted one. Running for office, lobbying, sitting in committee meetings, only to lose an important vote on the floor of a legislative assembly is frustrating and even disheartening. But the process is important. In God's mysterious providence, we in this country have been blessed with the liberty to govern ourselves through representatives. Perhaps the Lord's calling you to this work. I don't know. That's for you to decide. But if so, I hope this primer provides some encouragement and perhaps even some guidance to future service. If you find yourself serving in this way, may the Lord bless you with wisdom, courage, mercy, strength, and grace, and whatever else you need.
Thanks for listening. Tune in tomorrow for more from the Heidelcast, brought to you by Heidelberg Reformation Association.org. Don't forget, when the coin in the coffer clinks, the cost of bandwidth shrinks. Copyright Heidelberg Reformation Association. All rights reserved. This is a Heidel Media production.
The best podcast